Good morning, everyone. I'm just going to wait a couple of minutes, just in case we have some more attendees to join us. So just one more minute. Okay. Good morning, everybody. Again, I'm Elaine Green, Head of Membership Events and Awards at the British Safety Council. Welcome to our webinar this morning. The webinar will outline the latest changes in UK environmental law and will provide you with key insights into key issues over the coming months. Our webinar running time will be about 1 hour, and we'll take questions towards the end of the webinar about 10:50 or 11:50. The webinar today will be delivered by Simon Colvin, who is a partner at Whiteman's. Simon leads the environmental law team and heads the firm's energy and utilities sector. Simon is also a member of the Chartered Institute of Waste Management, who he also writes a regular column in their journal, and he's also a fellow of the Institute of Environmental Management and Assessment. So welcome, Simon, and now over to you.
Okay, thanks very much, Elaine. Good stuff. So I think I'm going to be given control of the screen. I'm just going to bring my slides up when that happens. There we go. So I'm going to turn my camera off as well so I don't distract you. So my camera will go off and I'll share my slides with you. Just give me 1 second. There we go. Good. I hope you can all see that. I can see it now too. Right, okay, good stuff. Well, I hope you all had a good weekend. It's great to be with you this morning. Yeah, quite a lot to share with you, to be honest. I'm sure you're all acutely aware there's been an awful lot going on in the environmental arena, and there's lots more to come for the rest of the year. You know, Keith and I were just talking about some of the developments that's been happening, and it's a really busy time. Environment seems to be way up there on a lot of businesses and individuals' agendas, and I suppose quite rightly so. I think as Elaine said there, what we'll do is we'll pick some questions up at the end, but if you do have questions, use the question function, and then we'll pick up on those questions at the end. We've got quite a lot to get through. I know we've got an hour, so I'm going to try and make sure we leave plenty of time for the questions at the end, but yeah, we'll make a start. So I've just summarised some of the topics I want to cover with you this morning. Brexit, EU law, something to touch on there. I think it's quite important and worth sharing with you. Quick look at the energy security strategy, a bit underwhelming to be honest, but worth touching on. UK transition plan task force, that's more to do with net zero, so climate change. Digital waste tracking, quite an important practical change that's going to come in the not too distant future, so worth you knowing about that. You might at this point be thinking, why is Simon talking to us about some of these EU related things? Well, that'll become clear as we go through, but I think that's going to have a big influence. So we've got the Corporate Sustainability Due Diligence Directive. That's quite a mouthful, so I'm going to call it CSDD for short. EU Circular Economy Package, again worth talking about, an EU development, but something that's going to impact us, no doubt. Nature-related financial disclosure, again, important topic to share with you. One of these talks wouldn't be complete without talking about the Environment Act. Obviously a big piece of legislation that came in at the back end of last year, and just want to bring you up to speed with a couple of developments on that front. Climate change litigation, a couple of recent sort of cases, a couple of things to hit the courts that it's worth touching on too. And then just to wrap up with some other news, there's just a few developments which maybe don't warrant their own slide, but probably worth just touching on a couple of those things as well. So let's get stuck in. So retained EU law. So I wanted to flag this with you because I think, you know, Brexit happened, environmental law was sort of a big part of that. And what did Brexit mean in terms of environmental law in the UK, governance of environmental law and all those good things. I don't want to touch on that in too much detail other than to say there's some changes being talked about by government in terms of that relationship between EU law and UK law. And very simply, what was meant to happen when Brexit occurred was that EU law that I suppose was integrated into UK law at that time was sort of captured. You had that snapshot, and that was going to remain. And that was the position. What we now see is the UK government saying, okay, well, that was the position, but what we actually want to do is try and understand where we've got that EU influence in UK legislation. And surprisingly to me, and I've got, I don't know if it's a surprise to you, but I'd have thought there would have been some sort of comprehensive list somewhere of how EU law was integrated into UK law, where it sort of influenced or impacted, but there isn't. So what the government are talking about is identifying and cataloguing retained EU law as a first step. Then what they want to do is undertake a substance and status review. So what is it? So what is the law? Where's it relevant? And actually, what's its status? What impact does it have? The idea being that once they know what they've got, they want to look at their ability to actually amend and change it, and to do that via secondary legislation. And that's really the idea of this new bill. At the moment, if the government wants to change anything, they need to do it by Act of Parliament. But what they're talking about doing is giving themselves the ability to do it by way of secondary legislation. And that's really about ending what's called this sort of special status of EU law in the UK legal framework. So removing that continuing effect of supremacy of EU law. A bit of clarity around that sort of relationship, and as I said, some further measures is required. I've posed a question there, and I suppose, interested to get other people's thoughts on this as we get to the end of this morning's session. But is that a good or a bad thing? Some of the stuff I'm dealing with, for example, around end of waste status, the ongoing influence of EU law in that space is a bad thing, because you've got lots and lots of case law that's developed over many years in the Court of Justice, the European Union, around what does it mean to discard waste and all these different things. And for me, that's a bad thing, because actually you see regulators like the Environment Agency getting themselves tied up in knots as to when something ceases to become waste. And if we want to be really progressive in the UK around the circular economy, that really needs to be addressed. So to be honest, I think if it's done in a targeted fashion, it could actually be a good thing. But if you speak to NGOs, I think they're quite worried, because they think the government might just use it as a way of watering down environmental law, environmental controls. But to be honest, I'm not sure that'll happen, because there's that much focus by NGOs and others on environmental regulation and holding the government to account. So, but we're sharing that with you so you can see something that's going to be happening in the not too distant future. Energy security strategy, I don't want to say too much about this. I thought it was just worth sharing. I'm sure you will have picked up on this yourselves. It was essentially just a reaction to the spike in global energy prices. It's pretty much the government saying, we need to say something. What can we say about this? To be honest, it didn't say a huge amount. It just followed on from a few sort of prior announcements from the government. So Plan for Green Industrial Revolution, Net Zero Strategy, and Energy White Paper, and looked at things like support and energy builds. What about the oil and gas sector? Perhaps a bit of reliance on them in the short term. Ongoing role for renewables, bringing nuclear back a bit, hydrogen, and some other things. I've got to be honest, I thought it was pretty underwhelming. It was hyped up a lot, and I was thinking, well, this is going to be really good. And actually, when it's published, you're like, well, really, is that it? So yeah, it didn't add a huge amount of detail in terms of what we already know. So I'll move on from that one quickly. This one's a bit more interesting, and I suppose I'll talk about the impact of this, and then sort of comment a little bit about why it's relevant to everybody. And I suppose I'll just step back a minute. I suppose what I've tried to do in this session is just pick up on things that have happened or are going to happen. And for me, they're relevant to everybody, because they're either relevant to your business, either directly or indirectly, because perhaps it's your customers, your suppliers, your supply chain that it'll be relevant to, and it's relevant to you. It may be that you're in the world of consultancy, and it may be that these things offer an opportunity for sort of new work areas, or just to update some of the services you provide. So that's been my approach, and hopefully you can see that as we go through. But just coming back to this slide, so UK Transition Plan Task Force. Basically, what the government are seeking to do is develop a climate change net zero transition plan standard by April next year for financial institutions and listed companies. And this is all about, I suppose, trying to standardise a process so that it becomes understandable for everybody. So that common approach, and I know that's being looked at in a number of different areas, but sort of importantly here, Transition Plan Task Force, it follows on from a green financing roadmap that was released last year. And essentially what it's going to do, it's going to introduce a mandatory requirement for plans to detail how those courts are going to decarbonise by 2050. Now, in terms of scope, this is for financial institutions, so that's your banks, sort of finance houses, sort of big insurers, and then you've got listed companies as well. So you might be thinking, well, actually, that's not my business, or I don't act for those people. But it will be relevant, and I'll come on to that in a second, to others. There isn't a mandatory requirement for net zero targets, so it's not saying you've got to reach this point, it's just you've got to say how we're going to get there, so a slight sort of nuance in that. But there's going to be absolute transparency around this. So although there isn't a requirement to say you will get to that point, you are going to have pressure from stakeholders, whether that's shareholders, NGOs, and I'll come on to the importance of that at the end of the session when I talk a little bit about some recent developments with climate change litigation. But in terms of, I suppose, the government focusing on the people at that top level, so that top slice, it will flow down to smaller businesses soon, because you've got to think about supply chains, you've got to think about, an entity's scope 3 emissions and where they're coming from. So if you target and focus that top slice, those, the financial institutions and listed companies, it will cascade down to others. Indirectly to begin with, but over time it will be direct. My expectation is these things will actually get rolled out to those medium corporates and smaller corporates too, as the years go by. Resources and waste. So I said at the beginning some of the stuff was a bit sort of higher level, a bit strategy, and also said that some of the things are a bit more practical, and they will mean on the ground changes. And this is one of the things that's going to mean on the ground changes. You might have sort of seen or heard or read about the intention for sort of digital waste tracking as a way of two things really. One is addressing waste crime, and the other is improving recycling recovery, thinking about the waste hierarchy. So a policy paper was published just back in April. I think you're going to get a copy of these slides. You'll be able to follow that link. You could Google it if you wanted to. But the idea is we're going to have an IT-based system that enables digital waste tracking. Now, they're hoping to launch it next year, back end of next year, early the year after. Don't want to be too much of a cynic, but I think the government's not got a great track record on launching very large, wide-scale IT infrastructure, and so whether or not they hit that deadline, I suppose we'll have to wait and see. But it's worth knowing that's what they're hoping to do, because actually this is going to impact, all of us. It'll impact Watemans, it'll impact everybody that's subject to the waste duty of care. So all of you, again, whether it's your business or the clients that you work with, just to highlight why. It's going to be relevant to relevant waste controllers, and actually when you look at that definition I've extracted from the Environment Act, you can see basically it's everybody that's subject to the waste duty of care. So all businesses, everybody that's producing holding waste. And as I said, the whole idea of this is to focus on the ability to track amounts, types and destinations of waste to help with circular economy, to address waste crime. But it's going to mean lots of wide-ranging changes to lots of different bits of legislation and guidance. So, it's going to impact waste duty of care in terms of Section 34 of the Environmental Protection Act. It's going to have an impact in terms of hazardous waste, transfrontier shipments of waste, waste permitting and licensing, and the duty of care codes of practice too. So, a real practical thing for all of you. And as I said, either it's your business or it's your client. So I'd encourage you to focus on it and understand it in a bit more detail so that you can be ready for the change that's going to come. Because in terms of how you report waste returns and track sort of movements and shipments and those sorts of things, it's going to be very different and better to get ahead of the game and understand what it's going to mean for you rather than being sort of at the back end of the process. Right, now, Corporate Sustainability Due Diligence Directive, CSDD. European development is the first thing I would say. So you're probably thinking, not really relevant to me, we're not part of Europe anymore, why do I care? It will be relevant, and I'll go through and explain why in a moment. Sometimes legal developments come along and I think, wow, that's a big one. That's going to have a big impact, and it's really important. So I've got a few slides on this, so you have to bear with me. But that's because I think it is very important to all of you. Again, because it will be your business, or again, because it's your clients that will be subject to it. So bear with me on this one, and hopefully you'll understand why it's so important as we go through. So it's something that's been talked about at an EU level for a long time, and the proposal came through in February of this year. The idea is it's going to introduce a sustainability due diligence duty, and that's going to apply to large EU companies, but also non-EU companies with significant EU activity. So you can see it's people that do business in the EU but perhaps aren't based there. The duty is going to be focusing on identifying, preventing, mitigating, stopping and accounting for either adverse human rights impacts or environmental impacts. So that's those two things, sorry, and environmental impacts, not all. And that's either in your own operations or those of subsidiaries or your value chain. So you can start to see this is actually really, really broad in terms of its application. The scope of human rights and environmental impacts, that's connected to international conventions and doesn't include climate change yet. So you can see they've actually gone quite highbrow in terms of the scope of this. And again, they list the relevant conventions that are caught by this, but you think about Basel Convention, things like that in terms of movements of waste globally and those sorts of things. So actually, everything you can think of in a human rights context and an environmental impact other than climate change is going to be caught by this. Who's it going to apply to? So there's some sort of handy definitions in terms of scope. Initially, Group 1 companies, so those with 500 plus employees and a global turnover of 150 million euro plus. So that will capture a lot of businesses and a lot of companies. You've got Group 2 companies, so that can be those that operate in high impact sectors. So think of agriculture, food, textiles, where they get 50% of their turnover from a high impact activity. So the ones that are listed there, and they've got 250 plus employees and a global turnover of 40 million euro plus. There's a 2-year grace period for those Group 2 companies, and it's only where you've got severe adverse impacts, so a slightly lesser requirement on them. But this is, again, another important consideration for UK businesses. Non-EU companies are caught. There's no employee thresholds for them, and it's just a turnover consideration. And the way it's going to work is similar to, if you have to deal with REACH, you might be aware of this, but basically you have to have what's called an authorised representative in a member state where you operate. So the idea being that you have somebody that's essentially answerable to the EU in a regulatory sort of control context, so that if you're not complying with the requirements, they can hold that entity to account. Article 3, who's the value chain? Very, very broad again, so it's activities related to production of goods, provision of services, development of products or services, their use or disposal, upstream, downstream related activities, business relationships. So you can see actually that's your value chain. So it's upstream, downstream, very, very broad again. Article 5, you've got to incorporate due diligence into all of your policies. You've got to have a separate due diligence policy and code of conduct, and you've got to have processes in place to implement that due diligence requirement. So you can see this is actually, but for me, this is a real step change. These are things that perhaps businesses have done voluntarily in terms of some of those different considerations. But now you can see that law is definitely stepping into the breach in terms of these things being required and mandating the different things that I'm running through at the moment. So for me, this is why it's such a big development. Article 6, just some of the more sort of practical things from the directive. You've got to take appropriate measures to identify actual potential adverse impacts on human rights in the environment, and that's both in terms of your own operations, subsidiaries, and value chain. You've got to take appropriate measures to prevent, mitigate potential adverse impacts, and that's collaborating, perhaps use of model contractual clauses. You've got to take appropriate measures to end and minimise actual adverse impacts. So you can see actually, again, broad-ranging sort of obligations to take different things and to do different things. And it's not just about what that requirement is, it's actually, well, crikey, what systems and processes am I going to have in place to do that? And then what am I going to need to be able to do to demonstrate these things as well? And again, coming back to the sort of scope of the impact, even if you're not doing business in the EU, if you engage with businesses that are, then actually you're part of their value chain, and they're going to need to make sure that you're doing these things, and therefore you're going to have your own systems in place to be able to report to them. So you can start to see how far the reach of this directive is going to go. There's a need to have complaints procedures in place pursuant to Article 9. Article 10, you've got to monitor implementation, effectiveness of policies and procedures, and there's a need for an annual review. And then Article 11, you have to report on this. publicly and annually on your website, so that information has to be made available so people can scrutinise what it is that you're actually doing. Just a little bit more detail, so just a couple more slides on this. Group 1 companies have got to have climate transition plans as well to show they can achieve that 1.5 degree requirement pursuant to the 2050 Paris target. So I talked before about sort of UK specific regulation. It's not about, you know, committing to get to a point in terms of net zero. And again, the same as here. It's not about saying you're going to get there. It's just about documenting how you're going to get there. Other things worth mentioning, specific provisions in relation to directors. If you're within a business reporting to directors, or if you're a consultant advising directors, if that company has a system for variable remuneration, then there's a requirement within this directive for that to be linked to the climate transition plans and achievements of that, so you can start to see people are going to be held accountable. And then there's a direct duty on directors to actually set up and implement the DD processes, procedures, and to ensure integration. And then they're meant to take that into account in terms of sort of human rights, climate, environmental consequences of decisions, short, medium, and long term, as part of that general duty to act in the best interest of the company. So again, I mean, wow, that's really, really significant, isn't it, in terms of how they're going to make sure that businesses are doing the right thing. And before I leave this topic, we'll have a very quick look at enforcement. So, you know, what's the stick at the end of all of this? Well, if you're not complying with the requirements, you've got a company that's not doing the right things, regulators can impose fines based on a percentage of turnover. So you think about things at an EU level, that can be pretty significant. You know, they've not said yet what the basis of that's going to be, but we see perhaps with other sort of competition type regulation, you know, 10% of turnover, 5% of global turnover, there could be some big numbers. But also there's going to be civil liability for victims of breaches who can then bring damages claims if an adverse impact causes damage to them, which could have been identified, prevented, mitigated, or stopped by taking appropriate measures. So yeah, some pretty big sticks that people are going to get hit by if they don't do the right thing. So in terms of timing, due to be approved this year and implemented by 2024, so it's not too far away. And again, as I said, I think that's a very big development, and I would encourage people to start thinking now, well, actually, what sort of practical steps do we need to start taking? And it's that sort of risk analysis, isn't it? Well, are we caught directly? Are we caught indirectly? If it's either of those, well, actually, what does that then mean to us in terms of what we need to start doing from a planning perspective? So definitely one to get ahead of if I was in your shoes. All right, let's move on to some other topics then. This is another one. This is an EU development. It's not UK specific, but I think it will definitely have an impact on us and an impact on businesses providing products and services into the EU. And I'll just quickly run through why. If we wind the clock back, we had the Circular Economy Action Plan back in 2020, which talked about, I suppose, what the EU saw as the value of the circular economy, and they talked about it in terms of trillions of euros, trillions of dollars at the time. And what we're starting to see is some of the practical steps coming through now in terms of how they want to make that happen. So back in March, there were a number of bits of information that came out from the European Commission. So we've seen communications in relation to making sustainable products the norm. So, you know, rather than the exception, then becoming the norm. There was a strategy that was published for sustainable and circular textiles, recognising that sort of clothing industry has got a big part to play in this. Communication in relation to eco-design and energy labelling working plan for energy-related products. So what do they want to do and what's the focus going to be in the next couple of years? And then we've had proposals for a new eco-design regulation, so updating the existing regulation. New regulation laying down harmonised conditions for the marketing of construction products. So, you know, being very clear in terms of what the climate and environmental performance or impact is of those products. That's quite a big thing because, you know, you may be aware that, I suppose, construction industry is being identified and singled out as having a very large role to play in terms of climate change, net zero, in terms of circular economy. So a bit of clarity around that, I think, wouldn't go amiss. And then finally, a directive to address greenwashing and to provide additional consumer rights in relation to the green credentials of products. In the UK, you might have seen stuff that I've said about this, but Advertising Standards Agency recently produced new sort of guidance in terms of greenwashing in the UK, so their expectations in terms of people's sort of green claims. EU going one step further and actually having a directive in relation to this to make it clear in terms of what is and what isn't acceptable for companies to be saying in terms of the green credentials. So just, I suppose, really recognition of the importance of that, because people are keen to shout about the green creds of the services they provide or the products they produce. And sometimes people do overstep the mark. So something that's important to be considered. Okay, so change tax slightly, coming back home, this is UK specific. This is looking at, so a lot of the talk at the moment is in relation to obviously climate change and net zero. Conversation is moving towards natural capital, biodiversity net gain, sort of nature focused considerations. And this announcement by the government sort of ties into that. Now, again, in terms of its application, it's about I suppose financial institutions, it's about large companies, but again, there's that flow down, there's that sort of cascade down to people that are doing business with them, their supply chains and others, and ultimately it will be rolled out to sort of medium and smaller entities as well. So either you're caught indirectly, caught directly, or you will be caught in the future, so worth knowing about it. Essentially, it's a draft reporting framework, and it's a method for companies to identify, assess and report on material nature-related risks and opportunities in terms of their activities. And basically what it does is it encourages companies to identify risks and then factor them into the decision-making process, while also identifying opportunities to sort of improve nature-related considerations too. It's a draft form at the moment, final version expected later this year. It's similar to the Taskforce on sort of climate change related disclosures. You may be aware of that, but the idea is that it will become mandatory in future. And the idea is that people are going to have to report on these things, those larger entities. But until that time, and even when that does happen, we will see some early adopters, I think, in terms of some of those perhaps more environmentally focused businesses, when they take account of their Companies Act reporting duties that they have to shareholders. There will be some early adopters of this, and we'll start to see people reporting on these sorts of considerations too. So yeah, definitely worth knowing about. Okay, Environment Act, here we go. There's a bit to share in relation to this. There's sort of three topics. There's targets, there's the policy statements, and there's also extended producer responsibility is worth touching on. Now, if people think back to the Environment Act, obviously came into force in the autumn. But one of the elements of the Environment Act is to look at targets to be set and fixed by the end of October this year for 4 topics. So you've got air quality, water, biodiversity, and resource efficiency waste reduction. It ties back into the 25-year Environmental Improvement Plan, which came out a few years ago. And the idea is it's about having something to work towards. It's about having something fixed. It's about being able to hold the government to account. You know, having one target, at least one target for some of these things does seem a bit odd, because actually that's quite hard to do. But I suppose that's the way it's been set up. So in terms of deriving those targets, there's a 4-step process. They have to work out what the scope of the targets is. There then has to be evidence-based proposals. Those 2 things have happened. We're currently in the public consultation phase. That kicked off 16th of March. It was due to close, I think it was due to close on Friday, actually, just gone. But because of a bit of, well, some concerns and issues that were highlighted, that's been extended to the end of June. And the idea is those targets are then fixed, as I said, at the end of October. The issues that we've been facing in the last sort of 3, 4, 5, 6 weeks is with the evidence packs. So as I said, the second sort of phase of this process was around evidence-based proposals. What the government didn't do was publish their evidence alongside the proposed targets, and people got quite upset about that, particularly because some of the targets were pretty weak, and so there was no evidence to justify that approach. So what we've now seen is that some of those evidence packs have been published and others haven't. And so to be honest, I think this is going to turn into a bit of a mess, because you can already see NGOs lining up to say, well, hang on a second, you know, these targets just aren't good enough. Then they're looking at the evidence pack. So I can see this whole process getting a bit bogged down. if I'm honest. And I would be surprised if we had any targets fixed by the end of October this year. But I could be wrong, let's see. But anyway, what I'd like to do is just look at some of the specific targets in each of these areas. So, beginning with biodiversity. So the targets in relation to biodiversity, to be fair to the government, there is more than one here. They have gone a bit further. By 2042, and this is in part derived from that 25-year environmental improvement plan, they want to increase species abundance by 10% against a 2030 baseline. The next one is a bit weak. It just says improve the GB Red List Index 2022 baseline. Doesn't say by how much or in relation to what. But that's those species that are at risk of extinction in GB. They just say they want to improve it. Next ones are quite interesting. So restore 500,000 hectares of wildlife-rich habitats outside protected areas against the 2022 baseline. And then the next one is increase tree canopy woodland cover from 14.5% to 17.5% of total land area in England by 2050. Now, some rather clever people have said that equates to about 25 million trees. Those last two bullet points in terms of restore 500,000 hectares and also canopies or woodland cover. There's a big move at the moment, and we've been getting involved in some of this, is to look at the value of natural capital and how the value of natural capital then actually drives people's investments in this to achieve some of these targets. One of the things I'll talk about in terms of other news is just biodiversity net gain. It's this idea that if you've got a development, it has to deliver a 10% positive impact in terms of biodiversity net gain, either on site or elsewhere. That requirement is going to have a significant impact, and it is going to drive investment in these areas. And we see private equity funds and others starting to get quite excited about actually the value of biodiversity, the value of natural capital. And one of the things I've started to talk to businesses about is, well, actually, if natural capital, if biodiversity does become very valuable, then actually at some point in the near future, you're going to see regulation of that in a planning context to say, well, actually, we've got too much of it. You can't do that. We need to use land for other purposes. That'd be a nice problem to have from some perspective, but can definitely see that coming because the value of biodiversity is just going to continue to escalate, particularly with some of these things that we've talked about. So just wrapping up on this slide, 16th of March this year, Nature Recovery Green Paper, again just reinforcing government's focus on this area and looking at what else needs to be done to deal with that. And then we also had a biomass strategy, which is due to be published this year. And it's a similar sort of consideration in relation to land use for biodiversity purposes. It's looking at the amount of available biomass and how can that be best used to try and achieve 2050 net zero targets. And recognising that actually you can't just use all of the available land for biomass generation, because again, it could just take over and it could start to dominate. So looking at what needs to be done in that area. Okay, so water is the next area where we've got some targets. Just keeping an eye on time, and I think we're okay at the moment. The 25-year environmental improvement plan said that by the end of that period, 75% of water bodies need to be close to the natural state. Sorry, that should be state. What does that mean? Well, what we see in terms of the Environment Act is trying to sort of bring through some of the practical things that need to happen to get to that point. So one of the problems we've got in this country is the impact on water bodies from pollution from abandoned mines. So the government wants to try and reduce that by 50%, or in terms of the length of water courses, 1,500 kilometres by 2037. Then in terms of nutrients, they want to reduce the impact of phosphorus, nitrogen and sediment from agriculture by 40% by 2037 against a 2018 baseline. And then the impact on phosphorus from wastewater by 80% by 2037 against a 2020 baseline. So once these targets, it's worth adding that I'm talking about lots of targets and different things. Once these targets are fixed, if it happens by the end of October or when it happens, you would then have to start saying, actually, okay, well, how are you going to start achieving these targets? How's that going to happen? And again, that's going to mean sort of further practical steps in terms of things that need to be done and further controls that come in to deliver these different changes that we're talking about. The final one in terms of water is water demand. So it's about reducing public water supply in England per head of population by 20% by 2037 against a 1920 baseline. And that's more around water companies thinking actually how can they can work more effectively in terms of managing water resources. So unless you work for a water company, perhaps not something that's specifically relevant to you. Okay, just this slide and one more in terms of the targets. Resource efficiency waste, I suppose quite a skinny target in terms of resource efficiency waste. They've sort of generally gone for quite a narrow one in this context, but actually one they think is going to have, the government think is going to have quite a big impact. So by 2042, reduce residual waste generated in kilograms per capita by 50% from a 2019 baseline, and that's excluding major minerals waste, so stuff from construction, and also excludes separately collected food waste that's sent to AD plants. But that's waste generated, and so you can think about lots of different things that need to happen. Some of the other stuff I've talked about in terms of eco-design and touched on. One of the things I'll talk about in a moment is packaging tax, waste plastics, and those sorts of things. There are lots of different bits and pieces that feed into this, which is relevant to the last bullet really on this slide, which is by 2042 eliminate avoidable plastic waste. And again, I'll talk about the plastic packaging tax in a moment. Okay, last but not least, air quality. Big topic in the UK for a number of years. We've had sort of the ongoing saga with Climate Earth and the government in terms of its clean air plans. Went round and round the houses. I think we ended up on the 5th or 6th iteration, and what we're now seeing is, I suppose that was pushed down to I suppose a regional level. I mean, I'm based in Greater Manchester. Greater Manchester Clean Air Zone has been postponed while they try and evaluate how it could actually be delivered and the impact on those that are going to be affected by the requirement. So, that's go slow. But where we've got to in terms of targets the Environment Act is to say in relation to particulate matter 2.5, England 2040, an annual mean concentration target of 10 micrograms per cubic metre, and by 2040 population exposure reduction target of 35% against a 2018 baseline. A lot of people have got really unhappy about this because in effect what we've plumped for is a target which was the same as the World Health Organization 2005 target, so something that's quite old, who are now on a 5 micrograms per cubic metre target, and there's nothing really knocked either. But as I said, people have got quite upset because actually see it as a retrograde step, and my expectation is that the government sticks with that legal target. We're going to see a legal challenge. You'll see Climate Earth stepping back in, or somebody like that, Greenpeace, whoever it might be. I suppose the issue, I suppose my thoughts on it is, but if you set yourself a target that you can't and won't meet, it becomes a bit nonsensical. So actually, where did the government go with this? Does it just have to be an open and honest discussion around the fact that, well, actually, this is where we're at, and we just have to go with what we can do, but perhaps have more detail around the steps they're going to take, try and move things more quickly if they can, to review it, on an annual basis. All of those good things, because I think otherwise it's not going to get through. People will challenge it, and people will ask for more. So I think that's an area where we're going to see some change, to be honest, and I think they will have to improve on that, shall we say. Okay, just a couple more bits on the Environment Act before we skip off the Environment Act as a topic. So the Environmental Principles Policy Statement. Just thinking a little bit about governance in terms of the Environment Act. People might recall, if you've heard me talk about this before, one of the consequences of Brexit was the fact that a lot of these sort of well-known environmental principles wouldn't be captured in the UK because they were derived from EU law, and there was nothing that was directly applicable in the UK. And so what the Environment Act sought to do was actually say, well, look, 5 key principles will apply in the UK post-Brexit, and they were the polluter pays precautionary principle, environmental protection integrated policy making, preventative action to avert environmental damage, and environmental damage rectified at source. So the Environment Act picks up those 5 principles, made it part of the governance framework by saying that essentially the government should have due regard to those principles in its decision-making process. I suppose the gap we've got at the moment is that the policy statement from the government has not been forthcoming. So although you've got those principles, there's nothing to say how the government should then take those things into account in terms of its decision-making processes, and that's a governance gap. Certain parts of the government are very sceptical about the principles. I think Rees-Mogg recently came out and sort of, was very scathing of the precautionary principle, thinks it's a bit of nonsense. So whether that sort of scepticism is feeding through in terms of the government doing what it needs to in this space, I would say that it's a requirement of the Environment Act that the policy statement is produced. So if the government continue to drag their feet, again, you can see an NGO taking the government to court, and the court directing the government to publish a statement. So I think it will come, but I come back to that scepticism. I think the government are worried that it will just become a tool for NGOs to hold the government to account, sort of litigate in relation to decisions, saying, well, how can that be in accordance with this principle, because it just doesn't work. So I think the government's just trying to get their head around that at the moment. But it's an important part of that governance jigsaw piece, so we can see that the government is doing things in accordance with the Act. Okay, as I said, last one in the Environment Act, just very quickly touch on this more for information purposes in relation to extended producer responsibility requirements. Extended producer responsibility is due to kick in next year, so summer 2023, and it's going to deal with things around producers to pay the cost of managing household packaging waste, payments to local authorities for collection of household packaging waste. Obviously, people have seen details around a mandatory take-back scheme for collection and recycling of disposable coffee cups. We have things around labelling of packaging for recyclability with a single labelling format, then annual packaging waste recycling targets. So a lot around there in terms of packaging, and you can see that in terms of the public's concern around those sorts of things. So a tightening up in that area in terms of packaging waste itself. Okay, so getting close to the end, so I think we're okay for timing. It's been a bit of a whistle-stop tour. I've got a couple more slides for you, and then I've released some time for questions at the end. Worth briefly mentioning climate change litigation and the latest developments in that sphere. Back in March, people might have seen this development, but Client Earth sent what's called a letter before action to Shell. Letter before action is essentially something you're required to do before you can actually bring a legal claim, whereby you give the party that you're intimating the claim against advance warning to say, if you don't do this or you don't address this, we will bring a legal action against you. And what that letter for action did was allege that Shell's directors were failing to prepare for the energy transition to net zero. They aren't doing enough. Client Earth are a minority shareholder in Shell, and so what they were seeking to do was bring what's called a shareholder derivative action for an alleged breach of Section 172 of the Companies Act 2006, and that's this just general requirement to act in the best interest of the company. So haven't seen Shell's formal response in relation to this yet. Not sure we will get to see that formal response, but I suppose we'll know whether or not Client Earth are happy with the response, which I'm guessing they probably won't be by their response to that, and whether or not actually a full claim does follow. You may have picked up, I think it was last year, that Shell were held to account by the Dutch government in terms of the net zero sort of transition plans and approach to climate change. So they've got a bit of a track record here. That I think that decision is being appealed, so it's gone to the Court of Justice of the European Union. So no doubt they'll be heard at some point this year. But yeah, you can see lots of different people. The message here is lots of different people, whether it be NGOs or governments, are holding companies to account in terms of their action or lack of action in this space at the moment. And then finally, just to mention, Friends of the Earth, they back in March were given permission for a judicial review of the UK's net zero strategy, and so you can see I talked about the willingness of NGOs to challenge the government in terms of what it's doing in this space. That's just a very good example of it, and I think that's undoubtedly an area that's going to continue to be very, very busy this year, next year, years after, as we see, I suppose, bits and pieces of the Environment Act come to fruition, and it's just a way of, I suppose, people getting things done. Okay, so this is the last slide, and then we'll pause some questions and switch cameras back on and those sorts of things. So chemical strategy, Worth mentioning, I think the last one we had was back in 1999. A new one was promised in the 25-year Environmental Improvement Plan. I understand there's been a lot of discussion over the last 4 years with government and sort of specific industry groups in relation to this, but nothing's happened. It ties into, I suppose, REACH regulation. It ties into circular economy. And yeah, I think the latest announcement I've seen is the government saying they're going to be hosting a series of workshops with interested stakeholders. It's meant to be in the spring, but I suppose coming to the end of the spring, aren't we, moving into summer? Workshops to be announced by the government in relation to this in terms of what chemical regulation should look like in the future. I think it was an event 1 or 2 weeks ago down in London whereby the sort of industry speakers, and they were, essentially saying that there's a massive opportunity around this in terms of circular economy if you get your strategy right, if you get your regulation right. So it's going to be really interesting to see what the outcome of those workshops is, and then actually how that then feeds into a new strategy for the UK. Biodiversity net gain, I talked about this previously. There was a consultation that closed earlier in April. It's all around this 10% requirement. So certain developments, you've either got to deliver 10% on-site or 10% off-site. If it's off-site, then where do you find those sites? The government have got to deliver what's called a trading platform, so people can trade in terms of those off-site improvements, and then there's going to be a need for an enforcement framework too. So big development if people are involved in development sector, but also I think it's going to be a big development in terms of driving, I suppose, natural capital agenda, and some significant opportunities there for landowners, for others, for consultants, for businesses to get involved. And that might be because your business needs to buy credits, needs to trade. It may be because your business wants to get involved in supporting projects. It may be because they have land whereby actually they can offer biodiversity for these trading platforms through things like conservation covenants. So yeah, another significant development that's worth understanding more about. And the final thing, which I'm going to mention, I'm not a tax lawyer, so I'll mention this briefly, plastic packaging tax. So this kicked in 1st of April this year, applies to produced imported packaging in excess of 10 tonnes, so there's a de minimis threshold. If you're above that, then you've got to pay £200 a tonne, where the recycled content of that plastic packaging is less than 30%. I think some of the conversations I've had with businesses around this is actually how do you go about demonstrating understanding that recycled content. So they sort of due diligence requirements and evidence packs. So if you, well, hopefully you know if your business is caught by this and it's something that's relevant to you, but if you don't, worth going to check, are you a producer, are you an importer? And if you are, and you haven't already addressed this, really focus on those due diligence requirements, the evidence packs, and making sure paperwork, if you like, is in order. And I think, if memory serves me correctly, that brings us to the end of the session, or at least in terms of what I wanted to share with you. So I hope you found that useful. Bit of a whistle-stop tour. I'm going to bring my camera back on. I think Keith may be joining us too, in terms of just hosting any questions that have come through to us.
Thanks for that, Simon. That was really excellent. In terms of questions, I've got one actually, if you don't mind me asking straight away. In terms of, so many of our members over the last few years have been dealing with the regulators. They're having some issues, particularly around sort of prosecutions and dealing with them. And so I'm aware that the regulators in the developed nations have had funding cuts and the pandemic. So as an environmental lawyer, are you starting to see their ability to prosecute or to do what they're supposed to do being affected?
Yeah, two fronts really. One is environmental permit applications, and the regulator's ability to turn those around is really being hampered at the moment. So, depending on the nature of the permit application, there's meant to be a sort of 3-4 month turnaround. People at the moment are talking about sort of 8-9 months as a minimum. Regulators sending back requests for further information to delay things before permit applications are being accepted as duly made. And it's actually having a massive impact. If you think about people that are trying to bring forward projects for new ventures or variations, sort of permits to enable them to expand or do things differently with their operations, it's making it really tough because, you know, big investments being made in those sorts of things, and actually if there's no certainty around the permitting requirements, it can become a real inhibitor. So that's one area where we're seeing a big impact, Keith. And then the other would be, enforcement prosecutions. There was obviously a hiatus throughout COVID whereby the agency couldn't get people into their offices for interviews under caution. They couldn't go out and investigate sites unless very, very significant. So there was a real sort of slowdown. We did see an upturn in terms of enforcement activity back in sort of October, November last year. There seemed to be a real drive to get back out there. But I think the issue that the agency are now facing is that actually, if there's a lot of stuff you read in the press that they're an unhappy organisation and they're under real pressure, pulled in lots of different directions. And you definitely see that because they're not very proactive at all. You know, we've had some recent examples, some ongoing investigations. We had one matter which was proactively disclosed to the agency. This is 3 or 4 months ago in terms of some unlawful activity in terms of hazardous waste. I heard from them, not heard a thing. And if I wound the clock back, 2-3 years ago, they'd have been wanting to meet straight away and discuss it. Nothing, which is very surprising. And then other ongoing enforcement matters, it's not unheard of. Again, in the past, they would have been fairly prompt at dealing with things, but it's not unheard of now to supply information to them. You don't hear anything for sort of 3, 4, 5, 6 months. And you've got clients saying, has this gone away? Can I treat it as closed? And I always say, no, you can't, because I've had bad experiences of people getting a bit too excited about a lack of news. Agency then come back 6 months later. So it's always that thing, you don't want to prod them because you don't want a sort of a negative response, but don't assume that because you've not heard from them they're not going to progress the matter. And then the final thing, Keith, would be the courts as well. So there's a massive backlog with the court system. So if something does reach the stage of a prosecution, it can take a long time for it to work its way through the process, through the court system, just because if you think about you're competing for time in a court system where they might be dealing with matters that are perceived to be much more significant, so sort of real serious or true crime, if you like, in that context. And so the environment stuff just gets put to the back of the queue. So there's been some real delays on that front as well. Okay,
great, thanks for that. Got another question here around some of the sizes of fines that we're starting to see, particularly in the UK anyway, with some eye-watering ones, and there was a £90 million fine last year. Is that something which you think that's a precedent, or are these sort of one-off show-stopping fines, or?
So I'm trying to think when the Sentencing Council guideline for environmental offences came in. It's probably 5-6 years ago, off the top of my head. And so the idea of that was twofold. One was consistency in terms of environmental sentencing across the courts. There was a recognised sort of lack of inconsistency. So you could go to the northeast and get one fine, you could go to the southeast and get another for exactly the same sort of set of facts and circumstances. So the guideline was designed to address that. And the other was also the regulators were pushing the courts to exercise their powers more in terms of the size of the fines. So, you think the courts have always had, Crown Court has always had the ability to impose unlimited fines on companies. But actually, I don't know, up until the guideline coming through, those fines were relatively small, particularly for some of the businesses. So it was pretty rare to get fines that exceeded 100, 200, 300,000 pounds. What we now see with the guideline in place, really around sort of large water companies, utilities, is they are facing significant fines and penalties. So I think if you did an analysis of the top sort of 20 fines or penalties over the last 3 or 4 years, they'd all be water companies. The 90 million one that you're referring to was, I think it was Southern Water from memory. And that concerned the falsification of data, reporting data from their sort of wastewater treatment plants. So they got, 90 million was the smaller of the 2 fines, because they also got in trouble with Ofwat. I think it was £120 million fine from Ofwat and 90 million from the agency. To be honest, I think the interesting one about that was a very significant fine, but what didn't happen was the prosecution of individual directors. People may or may not know that you can have individual responsibility of directors where offences are committed with their sort of consent, connivance, neglect. on that occasion, it was reported that was quite widely understood that directors had signed off or had knowledge or awareness of the falsification of data, and I'd expected, and others have predicted, that we would see, it would be one of the first times that we see in the prosecution of a sort of a board member. That didn't happen. I don't know why. That would have been a really powerful message, wouldn't it, if that had taken place? Because at the moment, the only prosecution of directors you tend to see in an environmental context is where you've got owner-managed businesses, and in effect, the owner and the company are the same. They're sort of controlling mind, so you have that sort of approach. So I would say that, yeah, you've got those big numbers that get reported for sort of utility companies. We have generally seen an upward trend in terms of other businesses too. So fines are more significant, more generally across the board. But yeah, certainly water utilities sit in their own bracket for fines and penalties.
Okay, great, thanks. And lastly then, I can take just one more question here. Someone's asked about the digital waste tracking. Did you say, I know you're going to share the slides, but did you say it was potentially going to be a target for next year?
Yeah. So the idea is to introduce the new framework next year. So back end of next year, early 24, but I think it was based around an IT system. So it's just a note of caution as to whether that's going to happen. But yeah, a real practical one for businesses, because if people will be familiar with, duty of care in terms of, okay, well, analyze, looking at waste carriers licenses and, where's my waste going to, consignment notes, all those sorts of things, it's going to change. And so it's a practical change for most businesses, and so therefore something that people need to get their heads around in terms of where do they sit in that framework, what does that change mean to them, what do they need to do in terms of how they operate.
Okay, great, thanks. Okay, I don't think there's any more questions. I'll hand back to Elaine if you want to just close up the session, Elaine. That'll be great. Thank you, Simon.
No problem, Keith.
Thanks, Keith. So just remains to say thanks so much to Simon for such a thorough whistle-stop tour of all the environmental legal updates. Thanks so much for that. We will post the recording of the session in the members area of the website. If you do have any other questions, please do send them through to events@britsafe.org and I'll pass them on to Simon for you. And that's it for today. I'll bring the webinar to close. Thanks so much to everybody who attended. Thank you for all of those who asked a question. And once again, thanks so much to Simon, and have a good rest today, everyone.
Thanks, everybody.